just wait for a thumbs up from the recording folks. Just let me know. Our technology doesn't allow us to instantly change between arguments.
We're good.
We're good. All right. Wonderful. We're here for oral argument on Westbrook versus Goodman. It's our number CV-25-0240. Both counsel, experienced counsel, you each have 20 minutes. Mr. Swan, you keep whatever time you like for rebuttal, but you have to keep your time yourself. Please proceed.
Good morning, and may it please the court, Peter Swan and Ilya Prokopets on behalf of petitioner Michael Goodman. I'd like to begin by addressing the questions the court circulated yesterday, which really did, I think, help focus the issues. Regardless of any joinder issues, the Superior Court did hold that husband had no claim that affected title to the property. At page 3 of its minute entry, the court specifically says he has no viable claim that affects title to the property. The Superior Court correctly acknowledged that husband had a claim to ownership of Westbrook itself. And by holding that claim did not constitute a claim to title to property or claim affecting title to property, the court erred. In a marital dissolution action, all of the property of the spouses, separate and community, wherever in the world it might be located, falls within the Superior Court's jurisdiction. Separate property must be confirmed to the owner. Community property must be divided, and it may be divided in kind, it may be divided by equalization, but all of that property is subject to the jurisdiction of the court. Indeed, it's odd that the court would say there's no claim affecting title to property when one could argue that a family case is the most comprehensive case affecting title to property known to state law. And because the division of community property can take any number of forms, including, as the Superior Court properly acknowledged, awarding one spouse ownership of an LLC, I would argue that inherently the LLC is property that is in play.
Let's back that up then. Your client's argument is that the funds that were ultimately used by Westbrook to purchase the property were community funds because they came from the law firm that at the time was considered to be a community asset. Is that right?
That is correct, Your Honor, although I don't know that that's essential to the position.
Okay.
Go ahead.
Assuming so, it seems like there's a few things that were in play here that the court could have done, assuming that, depending on the evidence that was ultimately presented, and one of which you said, well, it's ownership in Westbrook. But even if there is an interest in Westbrook that ultimately the court could decide, well, okay, that's a community asset, community ownership in that, how does that affect the title that Westbrook owns, even if your client is ultimately given a community interest in Westbrook itself?
Well, a couple of answers. I mean, that I think is the core question in the case. First of all, it is very important to remember that this is a case concerning a single member LLC. Everyone agrees that this is a single member LLC, which is different than an LLC that might have ownership interests from parties who are not part of the marital community.
But it still doesn't destroy the LLC status of the entity.
It doesn't automatically destroy the LLC's status, but at the time, and you've got to remember, this is one of 6 LLCs that the wife created, and one of 3 civil lawsuits brought by those LLCs against Mr. Goodman.
Well, counsel, I want to pause you right there because I don't want those facts to confuse the question here and what we're looking at, because it is an LLC, so it is distinct from the wife. And whether or not there could have been a claim that the two were the same, That's not what we're looking at here. So I guess what I'm saying is we want to stay focused on the fact that this LLC is a separate entity. So any determination of that is going to be without regard to who or the number of LLC members, separate some other determination that's not before us.
Well, okay, we can talk about the LLC as a separate entity, but the court will notice that there's been no groundswell of amicus filings from single-member LLCs trumpeting the importance of being distinct from their sole members.
So we do have JTF, a case that was decided just a couple of years ago in which we very clearly stated that Arizona respects the corporate form.
Absolutely. And the corporate form should be respected, but when the corporation here, the LLC, is both an entity and property that can be completely awarded to a single spouse, it is, I think, anomalous to suggest that the title to that property is not affected. What if that property were separate property? Then there would be a claim for an equitable lien, and a lien affects title.
Well, in an equitable lien, though, you're going to have to trace community assets to that property. And here, the trial court found that your client failed to do that and was unable to trace those funds to the TNA that then makes the loan that then goes to Westbrook.
The trial court did find that, but I would disagree with the suggestion that tracing is the essence of an equitable lien on separate property. An equitable lien on separate property arises from an increase in value based on a community contribution.
Well, I think
that
you're talking
does not
about
mean tracing of funds.
I think that's a marital lien.
I'm sorry?
A marital lien is what you described by statute. An equitable lien or a constructive trust, though, you're going to have to trace those funds. And you said you didn't do it.
I'm not arguing constructive trust here, but the fact that a lien can arise on separate property and the fact that community property may be transferred, even if it is done within the vessel of the LLC, does not in any way suggest that title is not in play or that the action doesn't affect title. The purpose of the Liz pendants is to provide notice to third parties that in this case prevents those third parties from unwittingly facilitating what might wind up being a violation of the preliminary injunction. And merely placing
But the
property...
preliminary injunction does not apply to the LLC as an entity, does it?
Well, it applies to the property that was placed into the LLC. And so to the extent that the LLC would then be used by its single member who is a party to the family case.
Wait, I'm sorry, I think you lost me. So the preliminary injunction in the divorce proceedings applies to the property in a separate LLC? Is that?
What the preliminary injunction applies to is property of the marital estate that may be transferred out of the ordinary course. The property, as of 2023, it had been ruled that the property placed into this LLC was the product of community property. That later changed. But at the time that this Liz pendants was in effect, there was every argument that property, that formation of an LLC and then the placement of the property into it was nothing more than an attempt to shield property of the marital estate from the jurisdiction of the family court. And of course, 25-211 makes very clear that the courts, or well, the legislature and the courts do not tolerate attempts to transmute property in a way that deprives a party of its community rights. So to the extent this LLC is created after service, significant amount of property is placed into it, and ultimately that is ruled to have been community property. I would argue that the preliminary injunction does apply to the transaction. Even though it's a self-dealing transaction, there is a transaction in which one spouse places community property into an entity. And yes, we do respect the corporate form, but we also respect the preservation of the character of community property. And so when that's placed into an LLC post-service, It is not a stretch at all to say that the court might have to consider whether to disregard the corporate form as an alter ego, whether the court might consider whether that transaction was a.
Did your client make that argument that the corporate form should be disregarded as an alter ego at any point?
I don't think it ever got to that point.
Or that there
What
was
I'm
a
talking about
fraudulent,
is the
or that there
inherent-
was a fraudulent transfer?
Is that there was a fraudulent transfer in the Superior Court? As
On
I
the
say,
part of wife, that she fraudulently moved monies all the way down to the purchase of the property and in an attempt to perpetrate a fraud on her
These were
husband.
summary proceedings, and it never got to that point, Your Honor. I'm sorry.
Doesn't that finding, mustn't that finding precede the filing of the Liz Pendens, though? The fact that the record is rife with opportunity to make that and perhaps succeed on that claim or that theory, doesn't there have to be some sort of judicial determination?
Absolutely not, Your Honor. Under 12-1191, it is absolutely clear that the Liz Pendens can be filed immediately upon the first pleading. What I'm talking about is the inherent nature of the action and whether it is one affecting title. But what happened here in both the Superior Court and the Court of Appeals is the court grafted onto the statutory language, it's just plain on its face, requirements that do not exist. And the legislature was not careless in the drafting of the statute. There are plenty of cases affecting title, quiet title actions, adverse possession actions, for example, where we don't necessarily even know who all the owners are, and yet this party requirement comes nowhere from statute, and the statute does not contain. I'm sorry.
No. I agree with you that you have to simply have an allegation. And so what I find missing is an allegation, or at least a claim, in the underlying family court proceedings that property that was owned by Westbrook was actually owned by the real property, by at least your client had an interest in it, as opposed to we have an interest in the community funds and money that she has used. And here's the distinction that I'm struggling with, and maybe you can help me. The money the best I could see that it could occur under the argument is that community funds were given to TNA. TNA then makes a loan to Westbrook, a separate entity, and then Westbrook uses it to buy property. Why isn't it that at most you have an interest in the account payable from Westbrook? You have the deed of trust. It's putting people on notice that there's a loan on it. And if there's indeed community funds, why wouldn't it be that? Or the court would make an equalization payment or something. But I'm struggling with why this is different than simply a claim for money, which is a debt, which is muchesco, that it's not going to affect a particular piece of real property.
Okay, well, Wachesco is a post-decree case, and title had already been decided in that case. So I think that the citation to that case was inapposite by the Superior Court, first of all. Second of all, let me give you an analogy. You can sell a business through an asset transfer or a stock transfer. The effect is the same. The buyer owns the business and its property. Here, if we respect the corporate form and the court effects a transfer of a membership interest, it is the same as a stock sale. The reality of the transaction is that title is being affected because it's being potentially transferred from one spouse to another. And we don't have to disregard the corporate form to get there.
If you have a half interest in Westbrook, then how is that affecting the title to property? The property is still owned by Westbrook. Somebody can still come in and buy the property from Westbrook. The only difference is your client is going to get half of the proceeds.
Not necessarily. There were 6 LLCs here. My client could have gotten the entire LLC and declined to enter into a sale.
They need to have the property.
I'm sorry?
They need to get the property.
Not if the property had been sold, and that's the point of the Liz Pendens, which, by the way, was filed after. The timing was not as nefarious as you might be led to believe. It was filed after the Superior Court ruled on summary judgment that the property was community property. So it was actually cautiously done, and the idea was to prevent.
Let me clarify something here.
We skipped a few steps.
You said that the motion for summary judgment clarified that it was community property. That was, which was community property?
The law firm.
The law firm.
Yeah.
So we still have the issue of, okay, so the law firm's community property. How do you get from A to Z? How do you say the law firm's community property, therefore the Westbrook property is community also? I guess this is what I'm struggling with. And I'll will let you know that what I'm looking at within that court order too was the court made a credibility determination with respect to trying to determine whether or not community assets really wound up in the Westbrook property. So based on that evidentiary hearing and what was testified to, what can you point me to that presents credible evidence that the Westbrook property was subject to a lis pendens?
The finding by the Superior Court was not a finding in the family case that displaced the equitable authority of the family case to affect title. The Superior Court in this case, in this civil case, found that there was not an ability to trace funds from the law firm to the purchase, but that was done in a summary proceeding to vacate a lis pendens, or to remove a lis pendens. You want to talk about due process. There was absolutely no opportunity to develop that record in the Superior Court in this civil case. If this had been the family case, and the full body of evidence had been marshaled, I might agree that the family court then can make a determination that there's no possibility of affecting title, and at that point, the lis pendens should be removed. But that doesn't mean it was groundless, and it doesn't mean it was knowingly groundless. All it means at that point is that the need for it has passed. But it is very clear to me that the title to, or the membership interest in this LLC, the sole membership interest, was subject to transfer between spouses. We don't know which spouse was going to wind up with it. And the spouse who wound up with it had the ability to determine whether that property would be sold or not. If a petition is filed and somebody decides to put their couch in one LLC and their socks in another LLC and their bank account in a third LLC, at some point we have to ask ourselves whether we are allowing the corporate form in a purely abstract sense with no factual development to interfere with the statutory jurisdiction of the family court.
The distinction from what you just said, though, is that the couch and the socks, and I can't remember what the third one is, were existing pieces of property within the community. You're talking about here, it's money, it's fungible. The money was used to buy something else.
But
I keep coming back to, why don't you simply have a debt here?
I would submit that 25-211 allows the court to examine whether that property was transmuted and preserve its character. Why aren't we talking about a debt? We might be. The court could decide to treat it that way, but the court is not required to. 318 makes clear that the division can be in kind, it can be by equalization, and the court, these parties still have not concluded their divorce. The court, those determinations haven't been made. With the court's indulgence, I appreciate all the questions, but I would like to save the remaining time for rebuttal.
Of course.
Thank you.
Okay, Mr. Berkshire.
It please the court, Keith Berkshire for the plaintiff in the underlying action, appellee, Westbrook Rental. I think the key question is here is, do entities mean anything? I mean, we have two statutes that say they do. This court has ruled that they do. Justice Bollock's opinion 4 years ago in specialty companies that you don't just get automatic alter ego and judgment enforcement just because you allege it later, that the statute of limitations applies to, in that case, to Meritage Homes, that even if they were the alter ego, they had to have been sued in the first place, and you don't just get to enforce against somebody you're claiming it's an alter ego. Title 25 is very specific, in this court in Weaver held that it's very limited jurisdiction. It's what you can do under Title 25. I don't doubt that courts, decide interests in property every day, and that's the job of the trial court in a family court case. But you can't dispose of separate property. That's a jurisdictional limitation, this court stated in Weaver. And here, there's no question that Westbrook Rental was started after the date of service, which makes it separate property. And now it's just an entity. And the argument, and I agree with the money that went into it, there could be a claim against that. There could be claims for fraudulent transfer. There could be claims for a multitude of other things. They just never made them. And they never joined Westbrook into the case. Title 25 has a specific joinder statute. And if you think about that statute, why does it exist? What are we going to join in? I'm not joining, the dog in on a custody case. You're joining in entities. You're joining in trusts. That's why the statute is there, is to join in potentially parties that have, common interests in these, or the parties, one of the most common things we have is, the parties have they're in a law firm with 20 other people. They're in a medical practice with 6 other partners. In this case, if this divorce is enough of an action to file a lis pendens, so I have a client that's a doctor, him and his 4 partners own the building under their corporate entity. Family court can't dispose of that. Family court can say what the party's interests are, husband and wife's interests are against each other, but sure as heck the family court, without joining that medical practice, can't say you've got to sell this building. And it would be the same patently unfair unless you sued that entity and joined them in a divorce case to file a lis pendens against it. There's no distinction just because it's a single member LLC here. The statute is a limited liability company is an entity distinct from its member or members. The same statute applies. It's 293108. It doesn't matter. This was never joined. There was never even an allegation that the entity was not operating as a legitimate entity. It was a legit real estate rental entity.
Well, what if, though, that and I noticed both parties form these LLCs and stuff. There's nothing wrong with that, and purchase property and do that. But, you're moving from one to the other and specific pieces of property. What if they were able to trace the community funds to the purchase of that property in Westbrook through the loan, through that, and if there would be an availability ultimately of an equitable lien on that property, do you have to bring the entity in before you try to enforce that lien?
I think you absolutely do. I don't think there's any way not to. Because again, what if the distinction they want to draw here is only if it's a single member. Their argument completely falls apart if there's anybody else involved. And how do you know there's somebody else involved when you recorded the lis pendens or anything else if you don't actually sue the entity? Because you never know. A lot of these could have a silent partner. There could be a separate contract. All you're looking at is potentially the corporation commission. It's why you have to sue the actual entity. I mean, I think that the legitimate rule here is to file lis pendens. The lawsuit has to name the entity that owns it. Because how else do they have any notice? And the thought that you could, if I own 1% of a real estate holding company, that my spouse could file a lis pendens against that real estate holding company and tie it up. And the case law dictates that it's tied up until it's completely resolved, which, in this case, it's 7 years. That separate holding company could be tied up for 7 years. I have multiple cases that are in the 10-year mark on divorces. I mean, you can't have that. And it's why I think the joining of the entity is such a key issue. And this court in the 1975 case, Kelly versus Perry, when the lis pendens statute first came along, one of the first cases after the lis pendens statute was changed from the common law, you just had to file a lawsuit. The Kelly versus Perry case, they sued the wrong parties. This court specifically, one of the findings in it, when you read through it, is that because the lawsuit was between 2 real estate investors and not the title owner, this is one of the reasons that they quashed it. And this court specifically said is that involving this third party that it could tie up their entity for years is what's inequitable and why you have to sue a party that's involved in it. I mean, this is not, your holding here isn't going to just apply to single member LLCs, because who knows if it is a single member? Who knows if somebody else lent the money? Here, TNA had a partner. So that person has an interest in Westbrook through their own deeds of trust and so forth. They have no notice of this. So whatever you do here, if you're saying that an entity does not have to be involved, just because the divorce has this overriding jurisdiction of anything the parties own, again, the amount of times that could impair a third party's interest, either member of the entity or a creditor of this separate entity, there's so many examples of where that is the world-ending scenario, not the opposite, that this is going to complicate divorces. This isn't complicated in a divorce. Make a claim for fraudulent transfer, join the party in, Jerobi, Coville, or Mezzi v. Firmano, those types of cases where have this other party in there, or just claim a right to money. Most of these are reimbursement claims. Most of them are just financial. You put $50,000 into this business after the divorce, you took it out of the checking account. Well, it was community. The court finds it's $50,000, you get $25,000.
The trial court, talking about monetary relief, relied on the Manchesco case and cited that and said this is akin to Manchesco. But your opposing counsel notes that it was post-decree and states that it's really irrelevant to what we're dealing with in this case. Can you respond? Does
I mean,
Manchesco?
I think the part of Manchesco that is relevant, I agree that I think it was a motion to amend or a motion to reopen under 327 on this. But it's still the concept that just because it's a divorce case, it's not the all-encompassing, always affects title to everything. Because in that case, she was requesting enforcement by getting a piece of property of some other judgment. So there's clearly not untitled. But again, just because the divorce case exists can't affect these third-party entities. Because again, you could affect there could be other members, which is the real problem scenario that, you own 5%, 10%, and this Liz Pendants ties up that entity for years. And the owners of the other 90% owners don't even have a concept that this exists. They're not following your divorce case, hopefully. But that's the problem here, why these entities have to mean something. And it's why 314D exists about joinder if necessary to, joinder should be if necessary to exercise its authority. Well, the authority is the court can divide all the assets between the parties, but necessary to exercise it means you have to have control over the entity. One of the cases I think that probably relates most to this is there's a Court of Appeals case that's been around for a long time called Noble v. Noble. And it was a divorce that the parties owned property in Denmark. And the Court of Appeals, and Noble's cited excessively in our case law, the Court of Appeals distinguished between, yes, I can order the parties to sell this property in Denmark. I can't, as a Maricopa County trial court, I can't sell it. I can't issue a deed that they have to record in Denmark because Denmark doesn't care. We're Arizona, they don't care. And the distinction of, yes, I can order the parties to do something, but I don't have jurisdiction over the asset, the actual property in Denmark. I have in personam jurisdiction over the party that I can tell them to go sign this deed. And if they don't do it, I can hold them in contempt. But they distinguish that it isn't actually truly affecting title because this court has no power over Denmark. And I think that's the difference. The court has power over the parties. But under 314D, to have the power to exercise its authority, that's where the joinder is required. So it's the same without joining this entity. If one of the parties is bolted and the court says, Westbrook is husband's. Okay, fine. The owner takes off. Husband can never enforce that until he sues Westbrook. He can't get an order out of this court or the clerk to transfer the ownership of Westbrook because Westbrook has never been involved, which proves that the court never had jurisdiction over Westbrook. It just had jurisdiction over the parties. And I think that's the distinction here and why holding that the family court would have this such broad.
Well, could the family court here order that that the husband has I'll just pick 50% share in Westbrook without suing Westbrook or without bringing Westbrook into the action? That's what I thought I heard you say, and that would be same with shareholders in a company and the shares. I don't know that you have to bring I don't think you have to bring IBN in.
Well, I think
to award shares.
I think you do, and I think that's where the Jerovi-Coville case comes into place. Originally, the trial court in Jerovi-Coville said that the husband, the wife gets 50% of the company. So in Jero, during a divorce, husband transferred. He's a IT guy and transfers all his clients to a new company started by his sister-in-law. And then that case came out before the data service met the termination community. It used to be the decree met the termination. So even though he did it after filing, it was still community because of an old statute. But what the trial court originally did was it says husband owns 50% of the company. Then on appeal, the Court of Appeals, the parties agree. The trial court had no authority to do that. It says that wife can get 50% of whatever husband has, and the determination of husband's interest has to be in a lawsuit against the actual owner. So the court can distinguish the interest between the two of them, but affecting the actual interest requires joinder of the entity.
That's different, though, than the scenario here, because in the scenario in that case, if I recall it correctly, the sister-in-law was the one that had the ownership, and the husband purposefully didn't have ownership, and the court said, yeah, but you really do. And so I'm going to give whatever you have. You have to work that out. But whatever you have, the wife gets half of it. Here, the wife is 100% member, the only member in the LLC. So I don't know that you would have to bring in Westbrook to be able to award husband any interest in that. And if you disagree with that, do you have any authority that kind of
Well,
counters that?
I do disagree because again, the issue is, who essentially can control it. So that would assume that the statute for LLCs distinguish between single member and members. The statute's clear that it's member or members. So there's no distinction that there's a separation here. There's no distinction in the other parts of Title 29, 3304 related to like debts, that there's no distinction that one member versus all of them. Because the court needs jurisdiction over the asset itself. And if an entity is by nature separate from the individual, it never had a control over it to divide it. It can tell somebody you have to sign something and enforce that via contempt, but it doesn't have control over the actual asset. There's a case that I think it's the Ferris case, that talked about there was a fraudulent transfer where an employee sued his employer, got some property, and then transferred it to his wife and his mom. And the fraudulent transfer for that case to actually affect title, the mom, who actually was the title owner, had to be involved in the case, because without that, you're suing somebody that doesn't actually have title to it. So I think that, again, the distinction is there. And it really, otherwise, why does 314?
Well, but the distinction in Ferris, that was fraudulent transfer of a particular piece of property. Here, it's money that is being traced up. And that's what I keep trying to get to. What was the court's option here? I'm not sure. I mean, I would think it's just an intangible asset is, a membership interest is the property you're dealing with. Is it not? Just like shares in a company.
But the membership interest clearly was established. Clearly was established after the date of service, which it's clearly separate property. What went into it, you could argue that it's community assets that went into it, but the membership interest was statutorily
and that's what
separate.
I guess I'm getting at.
So
what if it was community property that went into?
Then without joining the entity.
Even it's a separate entity, right, without joining the entity. What's the court's options there?
So without joining the entity, it's like a waste claim. It's either a waste claim or you just put it in your column. Here's the assets that you own. If you dissipate it outside the community, you can call it waste. Or if you want to get the asset back, like they did in Mezzi v. Firmano, when the wife sued husband's girlfriend because she actually had the asset. She had to sue her under fraudulent transfer to get the actual asset back. She can't sue husband for fraudulent transfer. He doesn't have the asset. To get the asset back, so to actually get title of the asset, Westbrook would have to be there some way, because you'd have to allege fraudulent transfer or something else. The court just under 318A, under what we call waste, which is a made-up term, but it's this expenditure outside the community. But it's you could do that without joining Westbrook. You just say, hey, you put $50,000 into it. That's waste. It's accounted for in the eventual property equalization, and you can do that. And that's the difference here. But to actually get to title, you have to have the actual title holder. And without the title holder, your claims are financial. And there's plenty of claims that are financial. Most cases, we don't join business entities in. We don't join the medical practices and all these types of things in, because we don't care. They're going to get an equalization out of the house or something else.
Let me ask you a question then about all these different potential types of actions and claims that could have been brought. And I think this may get to opposing counsel's broader argument here. I think his argument is that affecting title in the dissolution proceeding encompasses everything that you're talking about. They just didn't get there yet. So in terms of the filing of the lis pendens, when it was filed, is there an argument then that, well, all these other things could have been done within the dissolution proceeding and therefore would have affected title?
Well, first off, at the time that most cases look back at the time that the underlying action was filed, what's in the petition or what's done, this stuff didn't exist. So the underlying action and petition itself couldn't ever be looked at because they were predated the transfer or the establishment of Westbrook. I think it's the distinction between the court's ability to order my client, or the wife in the case, to sign something or so forth versus its jurisdiction over the asset itself without joining them. And I think that's the distinction that has to be made. I mean, I think the rule has to be, if you're filing a lis pendens, the lawsuit has to name the titled owner. I don't see a way around it without, because of the potential impact on third parties or the court's ability just to sign something to dispose of that itself. Can it order Ms. Wilson Goodman to sign a deed? Yes, but can it sign it itself through the clerk, like when we transfer deeds to property without one of the parties signing? The answer is no, because the title owner isn't in the lawsuit. So there's all kinds of equitable claims against the wife in this case, against Ms. Wilson Goodman, that can be made, but without, even if he made those, you still have to have the titled owner. It's in these other fraudulent transfer cases that they had to eventually add the other person, because that's the only way that we can actually get the title.
Assume they did then. Assume that they added Westbrook. Would that lis pendens have been valid?
If they added Westbrook and made a claim against Westbrook specifically after joining Westbrook into the divorce, yeah, it probably would have been. But because Westbrook has to have an ability to get out of the case. Because if Westbrook has 4 members, they have to make a claim enough against Westbrook where Westbrook can come in and file a summary judgment and say, you don't have a claim against us, so that those other members and the innocent parties can get out of the divorce case. Otherwise, they're sitting in the divorce case for a decade, and it's affecting their rights. Like this court said in Kelly, which is you can't impact these third parties by tying up their finances for years waiting for this other case to go.
Your time is waning, so let me get my question in. If that is so, then why under Richer is this a groundless claim, simply failing to bring in the appropriate party?
Well, I think under that case, I mean, obviously it was a case under 12-349 versus the versus Title 3-420 or 33-420. And I think the standard is a little different in considering that. And I also think that the facts of that case are different, where this court held that there was confusion of who was supposed to be sued, and the actual correct person, the Secretary of State, like the next day filed to join, and everybody agreed that they should be joined. So I think that the distinction here is if there was a confusion, but there's no confusion in this case at all. And that's what the facts unquestionably line out. I mean, this is 2 parties that spent somewhere pushing 7 figures on lawyers and so forth, and were, in complicated litigation that knew that they didn't sue the right party. They knew they never did this. And I would dispute the lining up of the facts of when this happened. Westbrook was restarted 6 months after the divorce was filed. The property was bought a year later. It went for sale 2 years later, and a couple days after that, the sale was contracted, the lis pendens came in. It's exactly why the sanction provisions of lis pendens are there, which is to, if you interrupt a sale and cause damages here, which was they lost probably $100,000, was for 75. I can't remember that those damage provisions, you prevented a sale. They could have done this 2 years earlier and recorded the lis pendens or fought something.
Mr. Swan said, and if I recall, it was 2 months prior to the lis pendens was the ruling by the trial court that the law firm was community property. Does that change things?
I don't think so, because again, they also had 2 years to try to make a claim or join Westbrook or have any determination of that in any way, or make a claim for the money.
Okay. Thank you.
Thank you.
Mr. Swan.
Well, Mr. Berkshire and I agree on one very important point, which is that the rights of third parties are entitled to due process. And if this were a case involving those third parties that you heard about for about 12 minutes, I would agree that joinder was very important. But here, Westbrook was the subject of a motion to consolidate. Mr. Goodman tried to bring Westbrook into the case, and Westbrook opposed it. The court adopted Westbrook's position, and it could have been a part of this case. It could have moved to intervene itself. It could have allowed the consolidation. It resisted being part of the case successfully. So let's remember that.
Doesn't that weigh against your client's position of then attaching a lien against a lis pendens against its property when it couldn't even be brought into the case?
Well, no, Your Honor, because the lis pendens was recorded before the motion to consolidate. If you heard an assertion that your holding won't only apply to single-member LLCs. Well, I'm not sure that assertion is correct. This case involves a single-member LLC, and the rights of all these third parties we're talking about are not implicated here. There may be a rule that affects, that requires joinder when third parties are affected, and a rule that does not when they're not affected. The court had
Counselor, let me
jurisdiction.
ask you a question because
Yeah.
time is running short. So just to be clear, would the court, in your estimation, have been able to enter an order directing Westbrook to turn over title to husband at some point?
Potentially. I mean, it depends on how that
It could have
claim-
ordered Westbrook or could have ordered wife.
Well, it would have ordered wife to act on behalf of Westbrook, and that plays into the Noble argument, because when a court orders a person to do something with their title, it has affected that title. The freedom to use the title has now been limited by the court. That affects the title. So Noble actually never held that the court couldn't affect the title in Denmark. It held that the court didn't have the full range of options to do what it would ordinarily have done with local property. The simple fact, Your Honor, is that the statute contains the elements. It's a carefully written statute, and the court here grafted a requirement onto the statute that does not exist. That's not the methodology that I'm familiar with this court embracing. So with that, I would ask that the court vacate the decision of the Court of Appeals and specifically find that the Liz Pendens here was not groundless. Thank you.
Thank you, Mr. Swan. We'll thank both counsel for your argument today and your briefing. We'll take the matter under advisement, issue a decision in due course, and we'll stand adjourned for the day.